So the book is about how decision makers can determine claims for recognition of refugee status by people who seek that status on account of disasters or climate change in their home countries. So what I did in the book was look at how decision makers historically have considered these kind of claims by extracting over 200 cases from the UNHCR's RefWorld database and looking at the kind of epistemological assumptions underpinning the decisions, as well as doctrinal assumptions that also affected how the claims were decided. So the epistemological assumptions relate to the meaning of natural disasters. And there was a really heavy prevalence of judges as well as academics articulating this pretty outdated view that disasters are natural, drawing on political ecology insights as well as what's now mainstream disaster risk reduction thinking. The book took a different approach and looked beyond the hazard, which is associated with the natural disaster, to the social context within which disasters unfold. And so it was really heavily guided by this idea that disasters are not natural, but are the products of the interaction of hazards like cyclones, droughts, earthquakes, and so on, interacting with exposed and vulnerable social conditions. And when you take that social approach to understanding what disasters are, it's much easier to see the human context within which discrimination contributes to differential exposure and vulnerability. So people who are discriminated against in everyday life on account of their race, religion, nationality, membership of a particular social group or political opinion, those are the people who tend to be differentially exposed and vulnerable in a disaster context. So that provided a good and strong impetus for revisiting that received wisdom that we found in the case law that suggested that people who seek refugee status simply can't qualify for recognition because disasters are only forces of nature and have nothing to do with human agency. When it came to unpacking the doctrinal assumptions underpinning these decisions that we looked at, it was a matter of being guided by the Vienna Convention on the interpretation of treaties and looking at the meaning of the words in context and in relation to the object and purpose of the Refugee Convention. There has been a lot written about what it means to be persecuted, and at the beginning of the project it seems like everything was pretty clearly articulated, for example in James Hathaway and Michelle Foster's Law of Refugee Status book, which articulates a human rights-based approach to this phenomenon. But looking at the cases relating to disasters and climate change and thinking through this disaster risk reduction lens helped to identify some assumptions about the nature of being persecuted itself. And what I found was that throughout jurisprudence and academic writing on the meaning of being persecuted, there's a really strong event paradigm that plays out and affects how we think about risk on return and how people may be persecuted when they get back home to their own country. So how people can establish a well-founded fear of being persecuted. And so rather than seeing being persecuted as the event where somebody is exposed to a serious violation of human rights, whether it's torture or losing their life in the context of a disaster, that moment, the approach that I took and the recalibrated definition that I articulate in the book sees being persecuted as more of a condition of existence. And now the implications of that remain to be seen, because it depends on whether the argument is persuasive to the reader, and particularly judicial and academic authorities who may read the book. But because it promotes a doctrinally very well grounded argument about why we should understand being persecuted as something that is more than simply the event of experiencing a serious denial of human rights, I think the implications go much further beyond the particular context of refugee status determination in the context of disasters and climate change. It can apply in the same way to claims based on sexual orientation or gender identity, military service claims, pretty much any refugee status claim one can imagine. The recalibrated definition that I propose in the book could potentially change outcomes. When it comes to claims for refugee status in the context of disasters and climate change, the book is sanguine, really. It doesn't propose that the approach taken will open the gates for people who have to leave their countries in this context. Far from it. It recognizes that the Refugee Convention is a very narrow instrument, and the number of people who can satisfy the definition of a refugee under Article 1A2 of the Refugee Convention are very few indeed, which means that other mechanisms certainly still need to be developed, and the Refugee Convention absolutely cannot capture and provide international protection to everybody who might need international protection in that context. Now, it's exciting at this point in time to have the book coming out, because we've, at the Raoul Wallenberg Institute, just now commenced a new research initiative where we are, together with the Ludwig Boltzmann Institute for Human Rights in Vienna, started looking at judicial decision-making in Swedish and Austrian court contexts. So we've already started to identify cases, and it's now a matter of analyzing those cases to see if some of the tendencies identified in the book play out in these particular national judicial contexts. So watch this space.